My name's Misheck, Daka, and my number is 1513633. That's my student number. This submission is for the challenge of the arbitral for Roland Sunshine Seashore Amusement Parks Limited. Firstly, the preliminary issues concerning jurisdiction and arbitration. The signed arbitral agreement has incorporated the London Centre for Arbitration Rules, the LCI rules, and under Article 16.2 points to the seat of arbitration as London, and therefore the seat of arbitration in this agreement is London. Article 16.4 of that rule points to the fact that the law of arbitration agreement shall be the law applicable to the seat of arbitration. Therefore, the Arbitral Act 1996 will be the applicable law of arbitration in this particular case. The Arbitral Act 1996 provides the legal framework in which arbitration is carried out. Section 1A of that act provides the object of the arbitration, and it does mention that it should provide the fair resolution of disputes by an impartial tribunal without unnecessary delay or expense. The main point that I'm making is that there's a fair resolution and impartial tribunal. Section 33, subsection 1, under the general duties, requires the tribunal to act fairly and impartially between the parties. Therefore, impartiality is an indispensable act of this arbitration. Section 24, subsection 1, entitles a party to apply to the court for removal of an arbitration on grounds that 1, that circumstances exist that give rise to justifiable doubts as to his impartiality, and that substantial injustice has been or will be caused to the applicant. Impartiality, therefore, is the cornerstone on which the arbitration principle is built. The office of an arbitrator requires him to act impartially without bias towards any party. He should not be predisposed to favor one party or act unfavorably towards any other. There is a serious danger of Dr. Gagarin being biased and therefore impartial in our case. His article, where he advocated for a relaxed approach to performance of contracts in the amusement industry, demonstrates that he has preconceived prejudices about the issue in dispute. His views in the article were extreme in nature, and the publication was not just in an academic legal journal, but in the public newspaper. This is evident that Dr. Gangren will be incapable of acting impartially. In accordance with Section 24, subsection 1, we submit that justifiable doubts have now arisen to Dr. Gagram's impartiality, and therefore he should be removed. And if he's not removed, he might cause substantial injustice to Roland Sunshine Amusement Park. And then there's the issue of independence. Although the Arbitration Act 1996 does not in particular mention independence, the London Centre of Arbitration Rules, which have been incorporated into the agreement, requires that the arbitrator should not only be impartial, but also independent at all times. Dr. Gangren's independence, therefore, must be examined under the rules of the Act. Independence requires that the arbitrator should be free from any relationship which may call doubt to his independence. The fact that one of the lawyers of Jandes has provided a laudable recommendation for Dr. Gangren in a case where they were both working together demonstrate that Dr. Gangren has more than just a casual relationship with the cancer of Janus. He is not independent of Janus' cancer. The argument that Dr. Gangren may be able to set aside that relationship and arrive at a decision entirely based on the fact and the relevant law is difficult to prove the absence of partiality. Justice must not only be done, but it must be seen to be done, as it is vitally important that confidence in the tribunal's ability to act fairly is not only established, but must also be maintained. I submit that Dr. Gangren's lack of independence is a pointer towards his partiality, and for that reason, he should be removed.